Basic Appraisal Principles, page 110, Unit 2, Real Property, Concepts and Characteristics. Be a requirement to replace the locks, purchase a new remote, or purchase a new electric door opener. The appraiser must consider these issues when evaluating the value of real property. Adaptation, the character of the item. An item that is built in, custom made, or constructed or installed to fulfill the specific purpose of the real estate is considered a fixture. Questions to ask include the following. If the item is removed, will there be value lost? Is the item necessary to fulfill the purpose of the real estate? Is the item useful only to the real estate under evaluation? For example, fencing for a pasture on a livestock farm, storm windows specifically made to fit the building, or a window, air conditioner installed in a wall slot, equipment designed for a wheelchair accessible home. Agreement, the item is written into an agreement. In some situations, the issue of whether or not an item is a fixture is settled by written agreement, regardless of any other discussed considerations. A written agreement between the parties stipulating how a particular item is to be treated will likely result in a court respecting and enforcing the agreement. The appraiser should obtain a copy of the written agreement to become familiar with any inclusions or exclusions of personal property, and carefully detail in the appraisal report whether these items are included in the value of the real property. Market customs. What is typical and acceptable in the market? Some markets have items that by tradition or through market custom are considered fixtures, whereas other markets would consider the same items personal property, such as major appliances, furnace, water heaters, air conditioners, and draperies. Appraisers must be familiar with their market and have the knowledge and supportive data to discern when a market custom deems an item a fixture and thus part of the real estate. Exceptions. As with most rules, laws, and theories, there are exceptions. In the law of fixtures, we have two exceptions: trade fixtures and emblements. Trade fixtures. Trade fixtures are items installed by a tenant for the purpose of carrying on a trade or business, but that the tenant intends to remove at the termination of the lease. The accepted rule regarding trade fixtures is that they may be removed by the tenant. If the tenant fails to remove the items at the termination of the lease, the items become part of the real estate and the landlord acquires ownership of the items. Page 111. For example, restaurant booths, gas station pumps, salon equipment, chairs, sinks, mirrors. Emblements. Emblements are a growing crop that is produced and cultivated annually and is considered personal property belonging to the party who planted the crop unless otherwise agreed. In an agricultural contract, the seller retains the rights to recover any emblements. For example, Mr. Jones planted and is growing corn on his farm. He sells his farm before he can harvest the crop. According to the agricultural sales contract, Jones has the right to re-enter the property to harvest the corn crop. The results of that crop belong to Jones. Extra notes. It should be over with the land section, and then it says crops, and it's pointing to cultivated annually. Something about its is forms purchase agreement permanently attached to the land. They are something mortgaged before grown.